Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're going to do a last week tonight where we answer your questions and we talk about your comments. It's all about you, the viewer, on this episode. So let's get into it. And Ace Boggy says, would being a former assistant wrestling coach be considered a loss of enjoyment and pain and suffering? It was the only sport I could give back to in the form of coaching. It really helped me to balance out teaching others. And now with my back issues, I can barely get into wrestling positions for long without intense nerve pain. Before my injury, I was way more capable. And I would say, yes, absolutely. That's exactly what a loss of enjoyment of life claim is, right? Because essentially you can claim and sue for pain and suffering, both past and future. But when they say pain and suffering, a lot of people just say, I can't wrestle, I can't, run, I can't lift weights. And it's all can't. And, there's a saying that says, to have pain is to have certainty, but to hear about pain is to have doubt. And you don't want the defense and the insurance companies to cast doubt about your pain, right? You want your pain to be truthful and to be honest and to be real. What you're really experiencing should be that out there in court. So I think it's essential in a case like that, just, front it, be brutally honest and talk about the truth of it, that you used to wrestle, get some of your former students that can come to court and testify about how you coached them in wrestling, how they, thankful to you because without you, they wouldn't be in wrestling, right? And it might have led them to college, to a scholarship, to their career, to the person they are now. And then get some other coaches, your coworkers, get some photos of either you wrestling or you teaching, your videos if you have it, right? Exchange all that. Have your lawyer, make sure your lawyer is a trial lawyer, that's number one, and have him exchange all that, her exchange all that with the other side, with the defense. Now you have witnesses, right? All you need to do is exchange their name. You could interview them in depth, right? You don't have to give all that to the defendants. All you have to do is exchange their name. John Doe, 123 Main Street. That's good. Now you call all these people, your coworkers, your former students, they come to court. Have each one of them think of a moment in time so you could actually go there, a moment in time, maybe the state wrestling championship, right? What happened right then? Maybe you gave them the coach, like in the Karate Kid, you said, hey, this is what you do, and then they won the whole match because of you. It doesn't have to be that dramatic, whatever they remember, right? And have each of them testify in court for like 5 or 10 minutes. And I think with that, they can't say you're a liar, a faker, and a fraud with all that evidence, what all these people are lying, all these students, all these other coaches, the teachers, staff, photos, videos from your life. It becomes like impenetrable. It becomes such a powerful, case. So that's what I would do. I really recommend that. And I think that could be the way for you to win the case and to get a really large amount of money on a case like that. And then Slip says, this is me. I was recently injured and can't go skiing. And he was responding to my short, pain and suffering, losing the experience. And in that video, I talk about the experience of doing. It kind of is related to what we just talked about with wrestling, right? So there's not being able to do something, like not being able to ski at all. There's being able to do something, but not as well as you could before. Like, for example, I could still sit, but I sit with pain, right? And there's also the experience of doing, like, for example, skiing. At one point, you could say, I love skiing. I love being in the powder. I love making my own tracks. I love being in nature. This is something I really love. I look forward to the winter because I want to go skiing. And now with, say, a herniated disc where you required a fusion surgery, I lose that mobility. I can't do it anymore. I try. I still want to do it, but now it's completely different. Before I would go out for like the whole day, 9 a.m. until when the lifts closed at 4 p.m. I would go to Colorado, Utah, Vermont, wherever, Europe, I would go all over. I really love it. Now I can't do it anymore. I try, my family and we go together, I try, but after 15 minutes, I'm in pain. I just have to sit down, I have to rest, I have to, I can't even put on my skis or the boots on my own. So it's a completely different experience, right? It's the experience of doing. So this question is, or this comment is, this is me, I was recently injured and can't go skiing, have an AVM possible rupture in my spine. We'll find out if I need surgery on Monday. So far, I need a cane to walk and still very off balance. Literally chair and bedridden from this fall due to negligence. Yeah, no, I'm so sorry to hear that. That's exactly like what my video was about. Also, you could do a kind of similar to what we talked about with wrestling, but you could do it with skiing or whatever else is important in your life. Absolutely. I think that's how you can make the case believable and get the biggest amount from the jury. And then civil rights has a question. Do you know what the duty owed of the employer to report the accident and injured employee to their auto insurance company? Employer was the owner of a well-known multi-location big dealership, and employer vehicle was a shuttle porter, and it was a multi-vehicle collision by Unit 1 failure to yield at the red light. So 100% fault. Vehicle was totaled and workers' comp was started, but did not report to the insurance for 6 weeks on the same date that their doctor did return to work as in light duty. It's a complicated case, and I feel that a tort claim against the employer could be argued. Any opinions? Yeah, I mean, I think that you're right. You know, they definitely, if it's the employer, technically you can't sue your employer because of workers' comp. So you have the workers' comp pathway, which is, lost wages as well as getting all your medical bills paid. But if they're like not reporting it to their insurance, if they're doing something fishy, you might be able to bring that up or start a separate claim against them if that's allowed in your state. So I'm happy to do like a consult if you'd like. You could just text me 347-566-9595. I think a lot of it would depend on your state law. In some places it may be allowed. I know like in Texas, for example, a lot of the time you can sue your employer if they don't have workers' comp, but in other places it might not be allowed, right? So everyone has their own law, so we'd have to look into that. And civil rights also has another question. How soon should a lawsuit be filed? I'm in Michigan, in a no-fault state, and the attorney failed to give guidance for the first-party PIP benefits, which were benefits owed by the employer's auto insurance. I had to file a claim myself from my son within days of the year statute. Third party seems to be what most attorneys are interested in. Is it advisable to contact the insurance handler directly and give them an opportunity for an initial settlement offer? I see. So you're talking about workers' comp, right, or PIP. Yeah, I mean, you could do that. You could ask them for an offer, but they might not really give you a fair offer by yourself. So you may want to contact, either have your attorney handle it, or if your attorney's not handling those kind of claims like workers' comp or PIP, you can get a workers' comp specialist in Michigan. I don't know what city you're in, but feel free to reach out. I know a lot of lawyers in Michigan, so I'm happy to recommend someone for you. And then Disna Lee says, in response to an old video about a bulging disc, whether it's worth anything, she says, this guy talks, but trying to prove the case isn't going to be easy. And talking money is a whole different ball game. Lawyers are like used car salesmen. They fake it till they make it. Then when they get you as a client, the real person comes out. He just wants to get paid. Oh, yeah, so I see what she's saying. So, I mean, yeah, I think she's right to an extent, right? You have to walk the walk. You can't just talk the talk. I think the brutal honesty of this one is that she probably has a bad experience with a lawyer or knows people who've had bad experiences. Lawyers, some of them, put up billboards, and they are like used car salesmen because they promise you things, but then when they get retained, guess what? They don't call you. They don't come to your house. They don't prep the case. So that could leave a bad taste in your mouth, and that can make you think, hey, all lawyers are bad. But, don't get that stereotype, because some lawyers are good. Some lawyers are true fighters for justice and passionate and willing to take the case to trial. So, it just depends. But I think that there's a few things here. She says, trying to prove the case is not going to be easy, and talking money is a whole different ballgame. Well, that's true. No one said that proving a case in court is easy, especially if it's just a bulging disc, because that's a soft tissue injury. So I'm not saying a bulging disc is worth millions without any surgery, without any procedures. Sure, right, that's going to be a smaller case, like 15, 20,000. And talking money, if she means in court, like asking for money, knowing how to get the jury to allow for big money, that's an art. That's being a trial lawyer, right? Picking the right jury and then being persuasive. And then she said lawyers are like used car salesmen, fake it till they make it. And then when they get you, the real person comes out. Well, yeah, that's one experience that people can have with lawyers, just like with doctors, right? Some people have a doctor and they're like, I love this doctor. And other people are like, you know what? I have this doctor, I just don't like him. It doesn't mean all doctors are bad. Maybe you just had a bad experience with one particular doctor. But I value your opinion, but I agree that you have to walk the walk. It's not just about talking the talk. It's really about, putting your money where your mouth is and following through. Alberto says, hi, Arkady, this is America. Millions of people with felony convictions and misdemeanor convictions Even Mr. President Trump, some people say no one wants to have an accident, but it happens. And she's responding to my raw law. And I think he's responding to the part where somebody asked about criminal convictions and how to deal with criminal convictions. And we talked about that live this week. So yeah, that's how I would do it. I would try to make a motion in limine, maybe to exclude the criminal conviction if the judge agrees. And if not, the judge says, no, it doesn't matter. That's coming in no matter what. Then you have to just front it and say, look, yeah, 30 years ago, 20 years ago, I made this mistake when I was 19. I had a felony. I paid the price, right? I went to probation. I went to jail, whatever it was. And now, 2 years ago, I had this new thing, like a ceiling collapse. What is this ceiling collapse and my injury and the person I am now have to do with what happened to me 20 years ago that I paid the price for already? And if you can't separate those two, if you're going to make me pay the price again and sentence me again to another 3 years or to a sentence of $0 for my injury, then maybe you're not the right juror for this case, right? Because there's other cases. There's divorce cases. There's real estate disputes, there's contracts, maybe you're not the right juror for this case. You don't have to be the right juror for this case. And you explore that in voir dire and you get rid of the ones that can't be completely fair and impartial, where both, the plaintiff and the defendant are starting on an equal playing field or behind the line, kind of like if it was a race, like a running race, you'd want to start behind the line. You wouldn't want one person to start here and one person to start here, right? It's not a fair race. So you explain that to the jury and then you get rid of the people that can't be fair for cause. And then here's a question from Sadea Ben. He says, hey, Frekhtman, my orthopedic requested a surgery to my lower back, but I am scared to do it. Does that affect the settlement in a certain way? I mean, can I still get compensation for my lower back injury without having surgery? Thanks. Yeah, you absolutely can get compensation, but it'll be less, right? So if you have a medical need for surgery, that has a certain value. But if you actually have the surgery, that has a greater value. So for example, if a doctor says, hey, you need a fusion surgery and you go ahead and do it, okay, now your case could be worth, let's say, $1 million. But if the doctor says you need a fusion surgery and you say, I'm scared, I'm not gonna do it, but I have this letter from the doctor saying I need a fusion, I might do it sometime later, like in 20 years. Sure, it's not gonna be maybe worth the same million, it might be worth, 250 or 300,000, it's still worth a significant amount, but you can't really, compare them because one person had the surgery and now they've had a lot more damage. They've had the pain and suffering of that. They've had metal. They have loss of mobility from the surgery. And then look, if they had one surgery, they might need a second surgery or a third surgery. And the other one is like, well, the doctor's saying, I need it, but I'm not even going to listen to the doctor, right? So now there could be an argument that you failed to mitigate or reduce your own damages because maybe the surgery would have helped you and you'd be fine, but you chose not to do the surgery. So you can't really blame the defendant for that, right? That's your fault because you chose not to do the surgery. So it has value, but it's going to be less. And then Richard also responds to this same comment, and he says, what if you already had back surgery, infusion, and neck surgery before you were hit by someone going 104 miles an hour on the job driving a 26-foot box truck? My truck was also flipped over. Very painful, but happy to be alive. Right, so that's different. Now, if you already had the surgery before you got hit by the truck, basically you could recover to the extent that your injury or your condition from having this prior surgery was made worse. I mean, obviously you can't recover for having a surgery because you had that, let's say, 2 years before you even had this box truck accident, but you're more vulnerable, right? So as compared to someone who has a perfect spine and no injuries, you have a prior back surgery, like a fusion, so you're already more vulnerable. So if this truck hurts you more than it would hurt someone else, then you're entitled to recover all of the ways in which it made you worse. And that's known as aggravation of your condition, exacerbation of your condition. So you're just, that's the argument that you take your plaintiff as you find him or her. Some people might be super strong, right? They don't really get hurt. Other people are more like Eggshell, meaning like, hey, the same contact that you tap a super strong guy, nothing happens. He just keeps walking, but you tap like a 80-year-old, like very, very Eggshell. The guy falls over, his head hits the ground, brain bleed, needs brain surgery, breaks his shoulder, breaks his hip, needs a new hip, needs a new knee, needs like, 20 surgeries. Well, you can't say, well, I should have hit the bodybuilder, right? You don't get to choose. It is like you break it, you bought it. You hurt this guy who was very vulnerable. You have to pay for all his damages. So that's what the idea behind you take your plaintiff as you find him or her. And then Terry says, thanks Arkady for talking with me the other day. My attorney is still pressuring me with the ultimatum of accepting the offer or find a new attorney. I'm so confused and frustrated. I don't know what to do. Yeah, so we spoke and I actually reached out to a local trial attorney. So let's see what they say. Maybe they can get you a second opinion or help you with your case. I hope so. That was a case where I thought it was a pretty good case. She had a lot of injuries. It was a simple case. Like one of the cars rear-ended and there were like 3 different cars involved. But it was funny to me, without disclosing any confidential details. It was just funny because one of them was like only a 25,000 policy, but the 25,000 policy was offering like 20, right? Which sounds like pretty fair, 20 out of 25. But then there was a policy that had more than $1 million and they were only offering 20, right? So they're like, wait a minute, but they have like, I think close to 1.3 million. So they're offering 20 and saving like 1.2, over 1.2 million. And then, so that just doesn't make sense. So I would push that car, the one with the million policy, and say, look, you have to pay much more because you have more and this is a serious injury. But, that's the way I would approach it. Orange Juice says, I don't know if this makes me a bad person, devious, or just thinking outside the box, but isn't being a lawyer a business? Hear me out. You got to know someone who knows someone who can ask for help. True, this is shady and bad, but it seems efficient in a way. Cough, Trump, uncough. Okay, so yeah, I mean, you're right. I mean, being a lawyer is in some sense a business, but there are certain, ethical rules, just like with doctors, certain ethical things that you have to follow. And you always have to think, what's in the best interest of my client? You can't always think, hey, what's in the best interest of me and my pocket? Because if that's the only way the lawyer thinks, then guess what? The lawyer will get really, really rich, but then it's to the detriment of the clients, right? Because the lawyer might get richer by taking more cases and settling them for like 30 and 40 and 50 and 100 and 10 and 15, but the volume, as opposed to doing one case the right way, but getting like, 2 million on it. But, but that's what's better for the client. So I feel like if the lawyer can't really devote the resources to the case, doesn't have the time, then they have to maybe like refer the case out or just not take the case. And then Charles has a question. Charles says, in a civil lawsuit, why is it that the presiding judge can lower the amount that the jury awarded to the plaintiff? One would think that the appellate court would have that responsibility if the case proceeded to that point. Right, so the way it works in New York is first, if there's a verdict, let's say like, the plaintiff asks for 3 million and the defense says, this is only worth 100,000, but the jury, for whatever reason, they get mad at the defendant and they give 20 million, right? So at this point, the defense can then make a motion to either set aside the verdict as not being reasonable because it materially deviates from what has been considered reasonable compensation in past precedents, right, in other cases. So then he could either set aside the verdict and do a new trial, or he could lower the verdict. So then the judge could say, yeah, look at the injury. This is what it's objectively worth. You only asked for like 3. For whatever reason, I don't know what happened in there, but they gave 20. So I'm going to lower it to like, 2.5. You could take it, or if you don't like that, you could then do another trial, right? And then if the judge's lowering of the verdict, if that is proper, then, then that just, the appellate division just kind of affirms that, right? And if it's not proper, the appellate division could say, you know what, we don't agree with what the judge did. We think, and that's like, 8 judges, and they all have to decide together, and they could say, you know what, we think it's another number like 1.8 or we think 3 is okay, or whatever they decide. But so it's kind of both, to answer your question. The judge gets to do it, and then the appellate division gets to do it as well. Sincere says, I had multiple herniated discs from neck to mid back and multiple bulging discs in my lower back. Been taking multiple physical therapy, but the pain keeps increasing. Also been having panic attacks, non-surgical or injection. What could this case be worth? I just want to make sure I know I get the best settlement offer. Yeah, so that's kind of hard to say because, herniated discs are the most common injury that pretty much everyone has after like a bad car accident or crash of any type. So in order to really answer that, I would need to do like a private consult, but it's free and it's confidential. So just text me 347-566-9595 because, if I was to tell you what a herniated disc is worth, I would need to know how much insurance there is, what city you're in, what happened, how the crash happened, much more detail. Otherwise, every herniated disc case where somebody says, I have a herniated disc, what's it worth? It would be worth the same, right? If I told you what it's worth. So it's impossible to say that just from a comment. And then Thayer has a question. Hi, sir. What if the police hit me and it was her fault? How much compensation? And he's responding to my video, how much is my commercial vehicle accident lawsuit worth? So if the police hit you and it's their fault, that's good. That goes to liability, right? So there's two issues. There's liability and then, or fault, and then there's damages, right? Damages would answer the question, how much is it worth? So liability usually doesn't answer that question. So the amount depends on the injuries you suffered. And then CC says, how about cervical radiofrequency ablation, C1, C6, and shoulder arthroscopy? Will this be handled as one or two separate injuries? So that would definitely be two separate injuries, right? Because you have a radiofrequency ablation and an injury to the C, which is the cervical, which is the neck, and that's that injury. And then you have an arthroscopy to the shoulder, which is a surgery where they fix like the ligaments or like the supraspinatus tendon, for example, in the shoulder through an arthroscopic surgery. So it's two separate injuries. Sometimes they could be related because, you know, there are nerves that go from the neck to the shoulder, but they're two separate procedures, so two separate injuries for sure. Here's a comment from Wright. He says, they're using my TBI to their advantage at the deposition. So now instead of asking for 10 and they don't break, we ask for 20 at trial. Like that, Mr. Frekhtman? LOL. Oh, I like that. So if they're using your TBI to their advantage, yeah, absolutely. You should call them out on that and explain how a TBI is a life-changing forever injury. And if you have a TBI and you're a victim of that, you can't, you know, be as articulate as someone without a TBI, and maybe have someone else help, like an expert, about liability. But absolutely, that could be worth a lot. And then Ace Boggy says, why did my previous lawyer who was helping me with a workers' comp case have to stop working on my case once he became a judge? I wasn't informed at all. This was in the process of happening, and it further delayed my case. Now I'm with a lawyer who hasn't even contacted me since I've given him all my documentation in the summer. It feels like these lawyers work with these companies and it's really just not talked about enough. The constant delays are just inevitably part of the process. I get it, but my life's been on standstill for over half a decade. Yeah, no, I'm sorry to hear that. Yeah, and just give me a text. I'm happy to chat with you. I'll try to help. 347-566-9595. A judge, you know, can't represent one side. So once they become a judge, they have to give up any private practice cases that they used to handle as a lawyer, right? Because a judge has to be completely fair and impartial to all sides. So I don't think a judge is allowed to handle a case. But if your new lawyer is not contacting you since the summer and it's already, you know, March, the summer is what, like July of last year, that's not good. So maybe, you know, reach out. I'm happy to put you in touch with somebody who will be more in touch and somebody who could help you. And here's a question from Morrow Desert. Arkady, my lawyer's paralegal called me to discuss a lousy settlement. Back surgery, foot surgery, mental anguish, and all backed with doctors. She said all you can get is $200,000, but lost wages and the lost job is over $170,000 with $45,000 in medical bills. On top of it, she recorded our conversation without first asking, is this normal? I mean, I think it sounds a little odd. It sounds like maybe she's not a trial attorney because look, if it's if you have 170 in lost wages, plus you have 45 in medical bills, so you're already at over 200 just in that. But then what about your pain and suffering, right? What about your loss of enjoyment of life? What about your future medical expenses? What about your future lost wages unless you are going back to work and you're making exactly the same amount? So it sounds like maybe they're not a trial attorney. Maybe they're just trying to persuade you to take what the insurance company is offering. Because remember, there's two ways you can go. You could ask for, let's say, $3 million, and the insurance company says, no way, we'll give you $200,000, that's the most we'll ever pay. So at this point, the lawyer has a choice. What do? Do I prepare the case and get experts and economists and fight and get my $3 million from the insurance company? Or do I fight with the client and say, look, I have $200,000 on the table. You know, why not take this $200,000? My fee will be $70,000. I'll just put it in my pocket. I can go have a nice dinner, go shopping, buy a bottle of wine. Why do I have to start this whole fight that might take another year to get this $3 million, which, you know, maybe I'll get it, maybe I won't. You know, it's who knows. But this 200 is a guaranteed thing. So what they do is they fight with you and they get you to take the 200 and then they just go on to the next case and they make money that way. But I don't really agree with that because it's not fair. It's not, you know, the right amount of settlement. So that's why I think that you have to, you know, have a real trial lawyer handle your case. Thank you, everyone. Thank you for watching. We really appreciate it. Our goal is helping serious injury victims and families. If we can help you, just text me. It's 347-566-9595. You know, when you text me, just text the brief facts, 1 or 2 sentences about what happened, your injuries, your date of incident, and that's about it, and your city, and then we'll get back to you. We'll schedule a time for a consultation, and I've been helping people all over Georgia, Florida, California, Oregon, Iowa, all over New York. I've been handling cases myself, so I'm happy to help you. And please like and subscribe to our channel, and all the best out there. Stay safe, and we'll talk to you very soon. Bye-bye.